Please be seated. We'll hear argument in 17-1048, Ortiz versus State Farm Woods.
May it please the court, Mr. Davis will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, good morning. My name is Joshua Davis. I represent Oscar Ortiz. Rather than having a new conversation, given the overlap with Barbara Technologies, I prefer to continue the conversation. But for that purpose, I'll address the breach of contract issue secondly, and we'll go to 542 and 541 issues to sort of jump off from where we were at Barbara. In response to Justice Lehman's question about why doesn't the insured demand appraisal early to avoid all this effort or trouble. Because appraisal is mutual with respect to who can demand the process, and it stops the parties from disputing the amount of the loss, that's wonderful for that issue, amount of the loss. But the carrier always maintains unilaterally the option to deny all of the claim or part of the claim based on coverage. And because the insured knows this, they don't want to demand appraisal, incurring the costs that necessitate from appraisal, umpire fee, appraiser fee, if the carrier subsequently denies that amount based on coverage and necessitates a lawsuit thereafter anyways, because the insured still has to hire experts in litigation to prove up the case. And so the idea that somehow it's...
Well, they may not if everybody's in agreement at that point in time. There's a lot of time-saving things that could accomplish.
I appreciate that, Your Honor, but for especially smaller claims, the cost associated with appraisal in the event of a subsequent denial are much more difficult to get back in subsequent litigation because you're also adding to the expenses of the case expert fees in litigation. And for a smaller roof case like Mr. Ortiz's claim, that the ability to obtain enough money in the litigation to account for all of those hard expenses that are not recoverable, right? The appraisal provision itself says the costs of appraisal to the insured are not recoverable. Likewise, expert fees in litigation, not recoverable, only attorney's fees. And so for that reason, these are hard costs that immediately go to the bottom line of the insured.
But following up on Justice Learman's question, when the insurer gives up some of those defenses, isn't that sort of a balancing of what's going on here?
When the insurer gives up some of what defenses, Your Honor?
Defenses that might be available to them for payment of the claims. In other words, they're going to go ahead and submit themselves to the appraisal process.
Well, Johnson v. State Farm lays out the insurer always maintains the ability to deny the claim based on coverage. And the liability question is always reserved to the court and to the insurer. So they are giving up defenses concerning the amount of the loss, but so is the insured. That's why the mutuality of that provision is fine. If you look at page 179 of the record, the appraisal provision, which is identical to Barbara and identical to many, many other appraisal provisions, only says amount of the loss and says it 5 times. But nowhere in the contract does it say our payment of this amount stops all other claims and damages, that King's X effect, which was the argument prior to Menchaca for this very issue in the courts of appeals. Because when coverage becomes the sole predicate question for all other claims that might follow in an insurance case, then the idea that there is or is not coverage is not relevant to the question of breach, right? And that's what Menchaca did. Now, the court is aware appraisal provisions go back over 130 years in this state. And it's just now that we are beginning to experience this argument from carriers that somehow it has the King's X effect. If we are now just experiencing this argument, why? It's because Brashears and all of its progeny, right? It was the Genesis case, 2004 Court of Appeals decision from Corpus Christi. If Brashears took Stoker and a misinterpretation of what this court meant when it said breach, when in fact the real issue is coverage. And Stoker led to a lot of cases, not just appraisal cases, that misunderstood the court's support for Vail and the ability to have an independent cause of action under the insurance code or common law. The Stoker decision spawned Brashears. Brashears spawned every other court of appeals and Fifth Circuit opinion and district court opinion that State Farm highlights in its briefing, where the insured loses on this issue. But Brashears was a misunderstanding of what Stoker was. Breach of contract is not a prerequisite to a 541 claim, 542 damages, or common law claims. Why? Because the underlying estoppel defense for a breach of contract is an equitable affirmative defense. It's a quasi-estoppel defense that purely exists to ensure fairness to the parties' understandings of the obligations that they previously made. The contract, the appraisal provision, no one, when they buy insurance, sees the appraisal provision and thinks, if appraisal's demanded and then paid, I'm somehow prohibited from pursuing any other claims or damages that might exist in Texas insurance law. It doesn't read that way.
They have to be independent claims or damages, or if they stem from the same nexus as the appraisal award?
And that's where Menchaca helps very much in terms of the entitled to benefits rule. If all that matters is coverage, and coverage can be answered in the affirmative, then the entitled to benefits rule means that the 541 claim and damages under 542 can flow from that question of coverage being answered in the affirmative.
If it's answered in the negative, then you can't get any of your bad faith damages.
I'm not here, Your Honor, for sure.
You agree?
And I'm not here under breach of contract, and I'm not here under 541 or 542. And that's what Stoker was really about, right? Which, by the way, was very bad facts. The plaintiff, and I don't even know if it was a pro se plaintiff, but the plaintiff in Stoker was making some fairly ridiculous arguments about how the failure to investigate a claim, even though there was absolutely no coverage, somehow created damages under 541. Well, of course that's not the case. The problem, pardon me, Your Honor.
Okay, I'm sorry.
The problem is that those bad facts and then the subsequent opinion that followed conflated breach with coverage, which Menchaca was designed to clarify. Now, sorry.
It may be obvious, but is the question of coverage resolved when either party invokes the appraisal process?
No, Your Honor. And Johnson tells us that. And
That's what I understood, so I'm having a little trouble with your argument.
I respectfully kind of move away from or disagree with Barbara Tech's argument on that issue. And that issue is decided both by this court and other courts of appeals. The question of coverage is not determined by the payment of an appraisal award, but the payment is evidence of coverage. And we're here on a motion for summary judgment. We can point to the payment of appraisal. We can point to all of the other documents that were contained within Mr. Ortiz's response to the motion for summary judgment as evidence of coverage of the claim that should be decided by the fact finder. Because State Farm could easily argue to this court or to the jury, well, we made the payment, but it was for, $6,000 or so, and we tried to or wanted to try and avoid some of this, so we just made the payment without wanting to put coverage at issue any longer. A jury or this court may view that evidence in that way and provide them a pass on that and allow them to continue to make a coverage-based denial going forward. I think that's much more difficult in Barbara Tech, where the disparity is so extreme and the evidence is much stronger. But that's fine for them to make the argument. But Mr. Ortiz should be entitled to make his argument that coverage, being the primary concern, is demonstrated, and part of that coverage evidence is the payment of the appraisal award when the process came so much later. I absolutely, the other issue I wanted to take up in terms of the Barbara Tech arguments, when appraisal is invoked, 18% penalty interest and damages associated with 542 pause. Okay? And that case law has also been decided, and I direct the court, the case that most clearly discusses this, although it's been discussed many times, is Quibido out of the Fifth Circuit, 2012 or 2013 case. But that issue has been decided. When appraisal is invoked, because the process is designed to hopefully resolve some of the parties' disputes, 18% penalty stops for the point in time in which the appraisal process runs. It begins on any amount that has not been paid by the insurer after the deadline for which the appraisal award should be paid. So we don't want to penalize an insurer, or frankly uninsured, for invoking this process. I guess it would be penalizing the insurer, for invoking this process, and the process does take time. The fact that the process takes time is accounted for by the pausing of the penalty interest. There were a couple other issues.
So you're saying then that if before lawsuit's filed and the appraisal process is invoked and an appraisal award or appraisal amount is presented and the parties agree to it, then there's no penalties, there's no prompt pay penalty at all?
No, Your Honor.
It's only when it goes into litigation because there's been a denial.
Well, I don't know that I would go that far even, because Ortiz views the appraisal provision as a form of a liquidated damages provision. Okay? That is, the parties agreed that they will liquidate their damages extrajudicially. But if it's a liquidated damages provision, think of it in another context. Think of it in a contract in which there's a liquidated damage for if I disparage you. And I agree if I do, there's going to be a $10,000 payment. There's clear evidence that I disparaged, but I say I'm not paying that, and you have to sue to get that liquidated amount. If 4 or 5 months into that litigation, I just said, okay, and let's assume also that because it's a contract, you've sent me a Chapter 38 letter, and you are entitled to fees because I refuse to pay within 30 days. If I pay 6 months into the litigation, the $10,000, I don't get to utilize that credit, and it's not a settlement, that credit as a means to avoid any other damages that stem from my breach. And I'll direct the court to 181, page 181 of the record, which is the timeliness provision within Mr. Ortiz's contract. That provision says there are outer bounds in which State Farm can pay a claim. Okay? And the outer bounds does allow for additional time in the event information is requested, in the same way that 542 provides such an extension. But if you read the contract, and if you read the appraisal provision, and if you read the statute, the idea is that information is requested prior to an underpayment or a denial determination. Prior to. If it were not that way, the insurance companies could simply write contracts saying, if we ask for more information at any time, despite any previous determination, we get a King's X to everything once we have the information in the event that we pay. That's the argument. That's the argument they're making. The demand for information can exist at any time, despite any prior acts that we make, including undervaluation or outright denial. And so long as we request additional information, we are obviated any responsibility that would otherwise be owed under the contract or under the statute. We cannot read insurance contracts this way. We can't read the statute this way. RUSI tells us we must, and this was a 2015 case from this court, and it concerned coverage, but it had to do with how we read insurance contracts specifically. It doesn't matter if Mr. Ortiz's reading of the contract is less reasonable than State Farm's. As long as it's a little reasonable, the court must find in his favor to the extent that it provides additional protections and coverage to insureds in the state of Texas. And why? Because going back to 1888, all the way through Arnold, RUSI, every single case that has addressed issues in which we are to be suspect of an insurer's motivations, and how they will go about writing contracts. Because when your profits are dependent upon maintaining premiums, and maintaining premiums are dependent upon paying or underpaying claims or not paying at all, that creates a substantial disincentive that can only be checked by duties that the statute and the duty of good faith provide. I see my time is about to be up. Yes,
Any
sir.
other questions?
I do, very
Yes.
brief. How do you spell quibido?
Your Honor,
Will you
I must
come back-
confess, I'm dyslexic, Your
Come
Honor.
back and let me know.
I will.
in your
I will look it
rebuttal,
up.
because it's not cited in either of your briefs, so.
No, Your Honor, and I guess it's only because I was trying to aid the court on that one issue. Yes.
Thank you.
Thank you, Mr. Davis. We'll hear from the respondent.
May it please the court, Ms. Lorber will present argument for the respondent.
May it please the court. What State Farm is asking this court to do is confirm what it has been writing about appraisal for 15 years, indeed for 130 years. But in the last 15 years, this court has explained that appraisals can provide a less expensive, more efficient alternative to litigation, that appraisals short-circuit litigation and should be pursued before resorting to the courts, and that appraisals require no attorneys, no lawsuits, no pleadings. Mr. Ortiz is asking this court to abandon this precedent. Instead, he advocates for a system that would use appraisal as the first step in litigation, where policy benefits would be decided and fully paid through the appraisal, but then insureds could continue to litigate to focus solely on trying to shift their appraisal costs to the insurance company and recover their attorney's fees. This is inconsistent with the insurance policy, and it's inconsistent with all of this court's precedent.
What if it was just other benefits under the insurance contract that they sought to recover?
That would be an important distinction, Your Honor, because the appraisal process sets the amount of the loss. It sets the amount of benefits you're entitled to under the insurance policy. So there are no further benefits they are entitled to receive under the insurance policy. If it was a case where State Farm or any insurance company did not pay the appraisal award, then there would still be benefits they were entitled to under the policy, but that's not this case.
So plaintiff submits a claim, hail damage claim. You go out, your inspector goes out promptly and looks and says, well, yeah, we see about $1,000 worth of damage. Yeah, it looks like over here there's some old hail damage, but that's from before our policy kicked in. Good faith, $1,000. They say, no, that old, we didn't have any prior hail damage, and there's a dispute over that. Good faith dispute. Either party promptly says, let's just get an appraisal. We'll do that. Let's get this done with. Appraiser comes back and says, yeah, it was old damage. You owe $10,000. You pay it immediately. And your argument is, now you can't, there's no, not only under the law as it exists, but policy-wise, there's no reason we should have to pay extra damages like the cost of experts or attorneys for that. But the scenario could be completely different. The insurance company, I don't know if you heard the first argument, but we talked about wannabe journalists who, the baddest of the bad guys. So wannabe insurance companies, baddest surplus lines, baddest of the bad guys you can think of, says, we don't want to have to pay this claim. It's a big one. Just ignore them. Doesn't respond, doesn't do anything. Finally says, nope, we deny the claim. And then there's further argument, and 3 years later, finally they file suit, or 2 years later they file suit, and the insurance company says, all right, they got us. Let's just ask for appraisal. Now your argument, your argument would be that all the losses and damages that may have occurred since then, in addition to the benefits, so the water damage that occurred because the roof, he couldn't afford to fix his roof in the interim and all that, you wouldn't have to pay for any of that.
That's not our argument, Your Honor.
Okay, so help me understand.
Okay, sure. I have a few responses to your answer. The first one is the facts of this case are your first scenario.
Sure.
But let's assume that some other insurance company would do the second.
Right, the hypothetical really baddest of the
Right. And so we're not arguing that an insured cannot recover damages he sustains that are independent from his claim for policy benefits. If something about when the policy benefits have been paid under the policy and there are no more policy benefits, the insurance policy has been complied with. So then we get into Menchaca, which fully explained what other types of benefits are available to an insured when there is no breach of the contract. And if the insured had sustained an independent injury, if it was a case, like in your example, where they couldn't fix the damage and it got worse, or something, I don't know what the hypothetical independent injury would be, but if there was one, they could recover it.
Well, we said in Menchaca that we still haven't found a valid independent injury, and maybe who knows if we ever will. But the whole point there was, if you're not entitled to the benefits, then you don't get anything else unless there's an independent injury. But here the assumption is you are entitled to the benefits, but you have additional damages on top of that that do flow from the benefits. And so under Menchaca, if they flow from the benefits and you're not entitled to the benefits, you don't get it. But if they flow from the benefits and you are entitled to benefits, don't you get it under 541 or common law? If there's a bad faith finding.
Potentially. And again, while I say potentially, is because in this case, that is not something that was alleged, and it wasn't something that was submitted in the summary judgment record in this case. The damages that he's seeking in this case are to shift his appraisal fees to State Farm. But the insurance policy expressly provides that the insured is responsible for their appraisal fees and does not have a fee shifting. Mr. Ortiz has presented this case repeatedly as not getting the benefit of his bargain, but he got precisely what the benefit of his bargain was. His bargain was an insurance policy that provided for appraisal in the event of a dispute about the amount of the loss, that does not have a deadline by which either party must demand appraisal, and which requires him to pay part of the appraisal fees.
But the bargain under both the 541 and the common law implies into that bargain a duty of good faith. If the insurance company, the baddest of the bad, violates that duty of good faith and thus causes all these extra fees, wouldn't the bargain require he get to recover those? I mean, that's part of the bargain implied by law.
The bargain, I submit, would never allow an insured to recover his appraisal fees, because an appraisal is doing precise. You're not in bad faith when you take advantage of an appraisal provision, and so his bargain was to pay for that appraisal provision. If there were some other damages that he sustained or that the delay caused, but again, this court...
Is he not asking for attorney's fees and other penalties like that?
He's asking for attorney's fees, Your Honor, but importantly, this court has held a number of times, and the statutes provide for it, that you have to recover substantively on a statute before you can get attorney's fees.
Absolutely.
And so he's not getting to any recovery substantively on a statute that would allow him to recover attorney's fees. And this is an interesting point. It reminds me how in his argument he was saying, well, the insurance companies are trying to change the law. Just now all this stuff is percolating up. What's happening, why this stuff is percolating up, is because insureds are just now trying to get their attorney's fees for the appraisal process. This isn't something this court has recognized for many, many years. It doesn't require attorneys. And in this case particularly, this court has already set up a process for how, in your example of an insurance company that was waiting an extremely long time and just not doing anything, and then went to demand appraisal. Well, this court said in Universal, there's a process that's already set up. The insured comes in, it says, I've been prejudiced, they waived it, they waited too long after impasse, and I've been prejudiced, and therefore we don't go forward with appraisal, and the case is decided in litigation. And if the case is decided in litigation, they get their attorney's fees.
But after a major catastrophic event, you have 50,000 people, Texans, with claims under $1,000, and State Farm decides it's going to deny all of them because they have to go out and hire an expert and hire attorneys and file litigation. Then we'll engage in the appraisal process. So there's not, the penalties sort of address the situation. So this goes to your earlier point, not the one you just made, that they're just now deciding to get their attorney's fees. That's not necessarily consistent with the idea of how this impacts consumers with smaller claims.
So, Your Honor, if you'll look at what happened in this case, again, your hypothetical may be something outside of the facts of this case, but it's certainly not this case. In this case, State Farm went out very promptly and inspected. It promptly gave an estimate. They had a contractor. State Farm went out, tried to meet with the contractor didn't show up, tried to meet with the contractor again, added some things to the estimate. This process went back and forth. State Farm worked with these insured, and they never...
These rules that foreclose all relief impact everyone. The bad of, when we're dealing with, did you say the bad?
Baddest of the bad.
The baddest of that, and we're not advocating for a rule that forecloses all liability. We're asking for a rule that allows damages to be recovered when they are sustained, when they are proven, but not in a case where your only damages are you prematurely rushed to the courthouse and you want to get your attorney's fees. I mean, in this case, they never let us know an impasse has been reached. Within a very short period of time, when we're still negotiating with them, they filed a demands letter on the same day as their lawsuit. State Farm, within a matter of a month or so, demanded appraisal, and the only fees they incurred in this case were fighting about going to appraisal, a fight that the judge held they lost. They did not prove prejudice, and they're not challenging that today. They're not coming to this court and saying this appraisal shouldn't have happened. They're saying, we want that appraisal, we want the amount of that appraisal, and we want to be able to say, oh yeah, but you waited too long, or I shouldn't have had to go through appraisal, and so I want my, and that's the only way they get to their appraisal fees being damages, is if they shouldn't have had to go through appraisal. But again, that's not how they're coming to the court.
But
so
your argument, right, is not that the good faith investigation that you say you're engaged in is the reason you win. Your argument is that even if you denied the claim in bad faith, and even if in bad faith you forced them to litigate and go to appraisal, they still don't get, they still can't recover that as damages. That is the argument, right?
they can't recover their appraisal costs and attorney's fees as damages, but if we cause them...
In bad faith.
Right, because the appraisal costs are the terms of the insurance policy. It's not damages.
And I'm just making that clear, because we have to think in those terms, not just about whether your client was acting in bad faith, but whether this ruling would protect anyone who
Sure,
does.
and the way that you...
That's strictly because the statute doesn't say you can get attorney's fees for bad faith. If the legislature decided after this case that needs to be changed, then that'd be a whole different story.
If the statute allowed you to get attorney's fees for appraisal, I mean, it would defeat the purpose of the appraisal process, but if it was the statute, then it would be a different answer. And to answer your question, the way that you protect insured from the hypothetical bad insurance company is by allowing them to recover independent damages or damages that they were harmed as a result of, I mean, State Farm fully complied with the appraisal process and is not harming them by making them go through the appraisal process that's in their policy. But if they had, hypothetically, had some other damages other than attorney's fees, then there would be a remedy under 541 and Menchaca. So the way that this court has talked about appraisal for a number of years is not that you never get to litigate about appraisal, but that there's 2 points in time then you could litigate about appraisal, and neither of them is after the process is over and the award has been paid. The first is, as I mentioned, if someone believes that appraisal is not appropriate in a case or has been waived or is untimely, you go to court then and you say it should not go forward. Or after the appraisal process happens, as the court explained in Johnson, you can come back and you can say, this appraisal award is not appropriate, fraud, accident, mistake, doesn't comply with the policy, and you can say it should be set aside. That's neither of the things that they're doing here. They're saying, give me my appraisal, give me and pay me what I had to pay to get through the appraisal. Give me the benefits of appraisal and don't make me pay any of the costs of appraisal. And they're really only they're looking for a remedy to try to get to their attorney's fees. And if there was one in statute, they may be able to do that, but there's not one in 541 or 542 that allows you to just get your attorney's fees because you didn't want to have to go through the appraisal process.
Expressed concern that Chapter 542 hadn't caught up with what you needed to say. Here I'm a little worried 541 hadn't caught up with what they needed to say, because it just seems to me that if you're right, that puts the insurers in a position where, so here it was what, $9,000 was or $10,000 or something was the total award. So, and State Farm had initially offered 500 or whatever it was, found that 9 out of 10 insureds, it doesn't make any sense to go to appraisal, but because by the time you've done that and come up with the $10,000 you believe you're due, as opposed to the 500 the insurance company's offering, you've spent more than that in attorney's fees and appraisal fees. It's a completely hollow remedy, and it may be that you're right, and it's just neither the statute nor the policies have caught up with that issue. But don't you agree that at least in some cases, it just makes appraisal completely hollow, because they're going to spend more getting the 10,000 than if they just took the 500?
But I could potentially, yes. I mean, I disagree a little bit. I agree that they have to pay their appraisal costs. I disagree that they necessarily need to incur the costs of any litigation to go through the appraisal process. And that's why a number of cases, I mean, insureds demand appraisal as often as insurance companies do, because although there are some costs associated with it, there are plenty of benefits. I mean, both sides have to pay a little bit, but you would have to pay a lot more in fees and costs and time and uncertainties if you went to litigation.
What is the average cost of an appraisal?
I don't know the average cost. I think in this case it was around $2,000 all in and this is when they had an umpire as well. It can be cheap. So each side pays their own appraiser. If they agree you don't need an umpire, you split the umpire. And it depends. I mean, they're appointing their own appraiser, so it's something that you work out with your particular appraiser.
The courts of appeals have distinguished Menchaca, saying it was an appraisal award case, and I wanted to ask you how you think it informs the issues here, setting that distinction aside. It's relied on pretty heavily by petitioners.
Yeah, and most of the courts, or I think all of the courts of appeals that have addressed appraisal since the Menchaca decision have tackled Menchaca head on, as the Court of Appeals did in Mr. Ortiz's case, and said, okay, we're going to look at your 5 rules, and we're going to see where you would fit in those 5 rules. And they're saying, yes, you were entitled to benefits, and you've been paid all of those benefits under the insurance policy. So you're not getting anything else under the entitled to benefits. Then we get to the independent injury, and like I've been saying throughout the day, we're not alleging that the independent injury would not be recoverable. We'll
just want to subsume everything into this appraisal award, though.
But no, Your Honor, if there was an independent injury, we would be still in litigation, litigating that independent injury.
If he had water damage because you didn't come out and he couldn't afford to fix the roof, then you're agreeing that if there was a bad faith violation
and an independent injury.
Well, that's the example I'm giving of an independent injury.
I think so. I mean, I've been trying since Menchaca, like the court, to figure out what an independent injury might be. One example I thought of is if we say, oh, it's covered, tear out everything, and then we say, it's not covered, we're not paying to put it back. Maybe that would be an independent injury. But, so yes, if there was an independent injury, we would not, I mean, that's not the argument. We're just saying that appraisal costs and attorney's fees are not an independent injury, particularly in light of the long line of cases that say attorney's fees aren't necessary in these cases. Appraisal is supposed to short circuit the need for attorney's fees in appraisal cases.
What is the effect if a insurer, after an appraisal, conditionally tenders the appraisal amount upon waiving extra contractual claims?
But I'm not sure I understand the question.
Is that an effective end of the matter?
If I understand,
Does it still leave something out there? So we're going to pay you on the appraisal, but we're going to condition the appraisal. You have to accept this condition to get the money, that you will waive all extra contractual amounts.
I think that would be a different question, certainly, than in this case. I mean, State Farm was not asking for any release or waiver. It's saying, we've paid the appraisal award, we've complied with the policy, we've given you all benefits you're entitled to receive, and we're saying, we get summary judgment on your extra contractual claims because you don't have an independent injury. You don't have an injury other than your claim that you want your attorney's fees for the appraisal process.
The benefit of the bargain will never include the outlay of cash to get what you should have gotten in the first place.
Not when it's under the terms of the insurance policy. What this policy says, what you should get out of this policy includes that your loss may be resolved by appraisal. That is the benefits of this bargain. So you're not harmed by the
loss is only that the roof. It's never the loss you're out of pocket to get to the roof. I'm using that as an
Sure,
example.
and that's the way insurance policies work. I mean, everybody's insurance policy has a deductible, so you're never, I believe everyone's does, everyone I've seen does. So there are things in your insurance policy where you're never getting 100%, and that's part of the way the insurance policy works. And
Unless the legislature provides for attorney's fees or cost or other types of claims.
sure, or unless TDI mandates the different, I mean, these contracts are approved, they're regulated and approved, and they've been around for 130 years, and they're around for a reason, because in hundreds, or I dare say thousands of cases, they are resolving these disputes, and we're not having to litigate all of these claims. So again, as I said in Barber Technologies, thank you for resolving this dispute, so we're not continuing to litigate it all over the state, and we again ask you to please affirm.
Any other questions? Thank you, Ms. Lorber. Mr. Davis, you have 5 minutes.
What is your response that these fees that you're asking for are not independent damages?
Your Honor, I want to make absolutely clear, Ortiz is not claiming appraiser or umpire costs as a damage that he can seek. I'm sorry that that impression has ever been made to this court.
What is he asking for?
Your Honor, he's asking for his attorney's fees and penalty interest under 542.
How could he get attorney's fees when we have a very clear American rule that you don't get attorney's fees if there's not a statute that provides for it?
542 provides attorney's fees for a violation.
But that's only if you're found to violate, if they're found to have violated the prompt payment, right?
Right to be liable, yes, Your Honor, and we want to try that to a jury and get a finding that, yes, in fact, there was coverage and it went unpaid and was not paid timely pursuant to the statute.
That's the Prompt Pay Act issue, which we also addressed in Barber Tech. Don't you also have claims under 541 in the common law?
Yes, Your Honor.
Are you seeking any different relief under those claims than attorney's fees and the 542 interest?
Well, to the extent that 541 allows for example, treble damages, to the extent that there was a clear and erroneous or knowing violation, that should proceed as well, and we should be able to conduct discovery on that issue. But that just highlights the fact we're here on a motion for summary judgment. So the only issue before the court, at least with respect to their arguments, was initially or originally estoppel for everything once we pay the appraisal award. Now they're arguing information that the appraisal somehow constitutes information we can demand despite any prior conduct to get out of statutory purgatory. With respect to the court's suggestion that 541 doesn't catch up, because we're only seeking attorney's fees and 18% penalty interest, and only for those points in time that exist in which effort was made outside of the appraisal period, because that stops the running of 18% penalty, and attorneys aren't involved in the appraisal process, so no work is being done. But the highlight of the umpire and appraisal fee is to show or demonstrate to the court that when the insured gets the 18% and gets attorney's fees awarded, it's not that they're particularly made whole, because they still have to eat the cost of the appraisal, but that's per the contract, right? We admit that. So I don't know why they ever believed that we were simply utilizing those costs from an equitable perspective. That is, the 18% and the attorney's fees have a clear purpose to attempt as best as possible to make the insured whole following an improper denial or a withholding of policy proceeds that belong to the insured. And I want to make sure that, I just kind of want to read this. The court in Menchaca on the 24th page writes, "But if the insured was entitled to the benefits and the insurer's statutory violation caused the insured to lose those benefits, the statute authorized the insured to recover those benefits as actual damage caused by the statutory violation, comma, even if the insured does not submit a separate breach of contract claim." And that's why we take Menchaca to say, your first primary predicate question is, was there coverage for damages sought for this claim under the policy? Yes or no? And this is how, with respect to the dissent in Menchaca, the answer to no on question 1 for this case does not matter. I promise you, if we proceed to a jury trial, Mr. Ortiz's first question will not be, was there a breach? The first question will be, was there coverage for the claim and the damages sought? Because the court's dissent intuits that the no to question 1 is likewise a finding by the jury that there was no coverage. And that was the line between the majority and the dissent. This case presents no such problem because guess what? We didn't get our jury trial because we're here on a motion for summary judgment. The last thing I want to do is point to J.A.W. Point. That case, which was highlighted in the Menchaca decision, demonstrates that the insurer's actions, even though contractually allowed, because they exhausted this $25 million collective policy for a multitude of commercial properties, there was a dispute about one, the main one, concerning, I can't remember which storm, but I want to say Ike. And the insurer's actions of paying off other smaller buildings, depriving the insured of the opportunity to get paid on the big house or the big commercial property, was allowable under 541 and 542, but the court determined there was no coverage anyways. So going back to, if there's no coverage, and there's nothing. But given that holding and applying it to a lot of the questions that the court has, there's no reason why we cannot proceed on 541 and 542.
Any other questions?
Thibodeau?
Yes.
Oh, I'm sorry, I did get it, Your Honor. Quibideaux, it's Q-U-I-B-O-D-E-A-U-X v. Nautilus Insurance Company, N-A-U-T-I-L-U-S. It's 655 Fed Appeal 984. 655 Fed APP 984. And I hope that I'm right on that particular issue. I know that there is case law on that issue. I think that's a good case to cite for that, but there is case law on the issue.
Thank you, Mr. Davis. The case is submitted. That concludes the argument scheduled for this morning. The marshal will adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned.